Yes, Mr. Sigda.
My lord, lordship is rising after for
1 o'clock.
division bench.
1 o'clock.
Therefore, my lord, I am to mention, my lord. In
Go on.
item number 19,
Hmm.
the matter relates to dispute between two co-wives relating to, my lord, terminal benefit pension.
But I think this has been compromised.
Compromise. So,
Ah.
my lord, it may be
Close.
disposed of in terms of the their
Compromise. But the respondent number 5 has appeared, no?
The service has been completed.
Complete.
but
The
they have
service
not
is
turned
complete.
up.
We'll pass orders, Mr.
My
Sigda. Ask your junior to be.
My lord.
Ask your junior to be here.
My-
We'll pass it.
Right, legal. For the content of other side, item number 4, I will be allowed to file a counter evidence.
Not required. Affidavit not required. You'll be here.
Affidavit will be there filed.
Yeah, affidavit, nothing is there. You just satisfy 2 queries, then I'll do what is required. Be here when the matter is called. That is that case now. You were posted in Dhubri. In Dhubri, you want to go to Hailakandi. You are working as on date. Are you working? Come back. Well, let it. 18 matter. Huh? Yes. No instruction is required. What instruction is required? No need. This is of 2019. Whatever instructions you have as of 2019, we will consider. Your present status, nothing. You are continuing. We'll put an end to that today. Be here.
Yes, sir.
Be here when the matter is called up. Yes.
So I will mention item number 6.
6.
The engaged conducting council is in Kolkata for this matter.
You be here. Be here. What is there left now? He's already discharged. The petitioner is already discharged from his service. There was no interim order. There are 5 councils. 4 councils available. Get any one of them. We'll pass out. Yes. Call. When the matter is taken up, call. You be here.
I have entered newly by having my color.
What happened to the earlier council?
Earlier council, I have no idea.
Now there is a development. I want to say there is 2 other legal hairs who have come up.
Yes.
Now, why was this? Okay, this is an aspect which came up after the last date, order of the last date. Mr. Barpujari, you have not released the amount.
We were about to release.
No, keep it.
But because of this development,
This is serious.
hold it up.
You hold it up. You
Yes.
have done correct thing.
They are holding up.
My lord, as per instruction, the petitioner asked them to give the details, but they have not agreed.
No, that
Yes.
in
my lord.
next of kin certificate is cancelled.
Yes. It has been cancelled, but
This is not pension. This amount they'll also be entitled.
Yes.
I can do one thing for you. Get into a mutual agreement, both of you. We will close the matter.
my lord, here one development is that the petition number 2 in IA, she has been curtailed by her relation by her father because she was not
Nothing doing.
Wait.
Those Tejaputri, that is of no use.
and she is with her mother, who is also a joint director in health department. As per their agreement, they have.
Bring those materials on record.
Yes, I may allow to bring that.
You file an affidavit against this, objection against this.
Yes, my lord.
Hmm?
I may allow to file.
IA Civil 277. Heard Mr. M. Ahmed Lanik Counsel for the petition, for the applicant. Also heard Mr.
SU Ahmed.
S.U. Ahmed Lanik Counsel appearing for the opposite party petitioners. Opposite party number
Opposite party here 1 and 2.
1 and 2. Oblique writ petitioners. So the present interlocutory application has been so instituted by the applicants herein claiming a share of the ex gratia amount which is required to be so released to the next of kin of late Hikmat Ali Ahmed on account of his death. after being infected by COVID-19 virus while being a frontline worker. Also, this court in the connected writ petition had in the connected writ petition, the respondents had processed the matter for release of the amount so due to the opposite party number 1 and 2 herein. However, it is seen from the materials brought in record in the present interlocutory application that the next of kin certificate basing on which the case of the opposite party number 1 and 2 were so processed was cancelled by the office of the district commissioner Barpeta. Also, in view of the above position, issued notice. Mr. S.U. Ahmed, Learned Counsel, accepts notice on behalf of the opposite party number 1 and 2, while Mr. R. Borpujari, Mr. A. Bora accepts notice on behalf of respondent number 3, 4, 5, 8, 9. 8 will be. Bora, madam, you will be appearing for 3, 4, 7. Opposite party. Write down in a piece of paper who is appearing for. Huh? Full stop. No formal notice is to be served. However, the Learned Counsel for the applicant shall furnish extra copies of the writ petition to the respective counsels appearing for the respondent authorities. Huh? Madam, you just write down. With opposite party is at liberty to bring on record its objection in the matter before the next date of listening. Also, list this matter again after 4 weeks. Huh? Also, it's not over. WPC. Also, in terms of the directions passed by this court, while order dated 12/8/2024, the respondent authorities were to credit the ex gratia amount in favor of the petitioners. However, on account of a further claim being made by 2 other legal heirs of the petitioner, of late Hikmat Ali Ahmed, late Dr. Hikmat Ali Ahmed, the respondent authorities are directed not to release the ex gratia amount in favor of the petitioners herein till the next returnable date. Registered to list this matter again after 4 weeks on a date to be fixed by.
Highly obliged.
We were with you, and unfortunately this has happened. Now
Yes.
they are also entitled.
Yes.
You disentitle them, we will pay you. Or
Petitioner number 1 is ready to
or both of you out of court, break your head, whatever, enter into an agreement. Otherwise, we'll not.
be obliged. Highly obliged.
Because madam, these interveners are the sons and daughters of the first wife.
Be that as it may, they are entitled.
Primary claim.
This is not pension.
Absolutely.
And I have examined the rules. It does not define family in terms of the pension rules. If it defined family in terms of the pension rules, they would not have been eligible. Both are around 30 plus.
Now, I say everybody will have an equal.
Equal share.
That is- I'm so obliged.
Highly obliged.
Yes.
May I please,
Hmm.
petitioner has challenged the appointment of the respondent by 8 my lord.
Hmm.
They have approached before this court since 2009 my lord,
Hmm.
by other writ petition also my lord.
Hmm.
Lordship may kindly peruse the order that 59.
Oh, we'll not peruse anything, Mr. Will you satisfy me with regard to page 136 and 137 of the affidavit filed by affidavit filed by the director, latest affidavit. After this, what is there? 136, 137. Yes, Mr. Chutia.
Yes, Madam, we have filed an affidavit.
Yes, yes.
We have stated here.
So the issue whether the respondent number 8 belongs to the area or not
My lord, it
After
is
this affidavit, it's not there.
by three annexes, my lord, it has been proved, my lord. They have also stated so.
Are
Which
where the
has proved.
Anganwadi center is now working, that is on the land of the
Private respondent.
private respondent number 8.
Well,
And
that-
she scored more marks than you.
that land was gifted, my lord, donated, my lord. She is not in the survey area, my lord. While the.
No, you have not filed any affidavit against this.
No,
My lord, we
No,
did,
no.
but they have not.
Show me your documents.
They have not filed
Okay,
as
show me your-
per order, my lord.
Show me your
Lordship, kindly
documents.
choose the last order, my lord, 15/9/2023. There is a specific direction in this order, my lord.
Okay, we'll forget everything. Now you show me
In
your,
this view of the matter, learned government advocate is permitted to bring the order of record by filing necessary affidavit
okay.
and supported. That
Uh,
enclose the order.
Mr. Bora, that affidavit is already on record. You have not filed a
But They
written.
have not filed as per the order, my lord.
Now show me from your materials that she is not within that area.
Lordship may kindly peruse Annexure C.
Page,
Yes, Lordship.
Forty-seven.
Annexure C, page 47.
hmm,
Earlier, they have filed a contempt case, my lord. It
Hmm.
was indicated, my lord.
hmm,
Point A, capital A.
hmm.
That the name of the present Anganwadi worker of Paschim Kholihamari Anganwadi Center, Srimati Purobi Devi, was not included in the original survey register of the year 2009. That is response number 8.
Now come to clause C.
See that
Hmm.
Srimati Purobi Devi, Anganwadi worker, had only recently shifted her residence area of Paschim Kholihamari Namghariya. Recently shifted, my lord.
Be that as it may.
During the survey, my lord, it was.
Need not
she
be.
was
When, when she had applied, she was there.
No, my lord. She was outside, my lord. The other.
Show me that.
Other documents also.
And then what next document?
Lordship may kindly peruse Annexure B.
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 B. Okay, B.
It
Ah.
is the order as per Honorable High Court's direction, my lord.
Hmm. B, B2, B,
B. Only
B, okay.
38.
Peruse the order dated so and so on receipt for.
Regarding point 3, Paschim
Yeah.
Kholihamari Anganwadi Center. Deputy Commissioner also stated so, my lord.
Director.
Report reveals that residents of petitioner Srimati Monica Devi and Srimati Sumitra Devi are within the concerned Anganwadi Center area. The child development project officer.
Okay,
Rahul
next,
SDF
next.
project also
So we
has
have seen B, C. Next. Next. There was a Gaubura certificate somewhere.
Number segment B1, my lord, page
Huh?
43.
40?
43, B1. 43, Bhaini Gula, my lord.
Read. Srimati Monica Devi.
Srimati
Aru-
Monica Devi আৰু সুমিত্ৰা দেৱী পশ্চিম খলিহামাৰী অংগনবাদী কেন্দ্ৰৰ নামঘৰ এলেকা আটাইতকৈ ওচৰৰ বোৱাৰী।
Asotke Usara Bori. Bottoman. Now, where is about Purvi? Where is about Purvi?
My lord, that report not stated about Purvi.
So
বৰ্তমান
now,
বিধৰ কৰ্মীয় সহায়িকা দুয়োগাড়ীয়ে প্ৰায় 2 কিলোমিটাৰ আঁতৰৰ পৰা আহি মাজৰ খলিহামাৰী অংগনবাদী কেন্দ্ৰ পাৰ হৈ আহি পশ্চিম খলিহামাৰী অংগনবাদী কেন্দ্ৰত নিয়োগ পালে।
Mane Koliamari, she has crossed Koliamari and then came.
And then appointment, my lord.
Okay,
Legally
then, what is the development? There are further orders. It went back to the project selection committee.
My lord, various documents stated, my lord, after inquiry also, my lord, that I am within the area concerned Anganwadi Center.
Who is appearing for response number 8?
They have filed reply also.
Now you come to page 64,
60.
CDPO's order after the project selection committee meeting.
Okay, fine. I have not noticed, served or not, I don't know, my lord. Nobody.
I'll
checked
check
it.
up, I'll check up. You have taken dusty service on her.
My lord,
Where is that?
there is also report, my lord. I have taken dusty service, my lord. We have filed affidavit
You
regarding.
have filed an affidavit. Yes, you have filed an
On
affidavit.
18/5/17,
82.
long back, my lord, on 18/5/2017.
82.
Dusty service notice annexure 1.
Okay, where is that witness there? That Purabi Devi had refused to take notice. There is no witness, only your statement is there.
That the respondent number 8 has refused to accept receive copy of the dusty service notice dated along with a copy of the writ petition regarding. My lord, they have appeared and filed affidavit, my lord.
Oh, respond number
In
8.
this case.
Who is the advocate?
Sorry.
Respond
Yes,
number 8.
sir.
Robin Dwara. His name is reflected.
Robin Dwara, my junior, my.
Name is not, sir.
My sister.
Okay.
BK Sharma is appeared.
Perhaps they missed it, Manoj, maybe it's not.
No, wait 1 second. Where is that affidavit? It's there. Respond number 6. Respondent number 8.
We have also filed reply to them.
90. Tutumoni Bormon. So item number কি নাম?
Respondent number 8 have filed affidavit on 5/6/17.
Respond number 8. Names are shown.
Not shown.
Yes, T. Bormon.
The,
Mrs. T. Bormon.
no, P. Bormon,
Respond
yes,
number
yes,
8.
my lord. DK
Can you just check up who this T. Bormon is? We'll finish. Just check up. Come back after some time.
After some time.
After some time. Yes, Mr. Pathak.
Lordship,
How is why the case of the petitioner is not being considered?
Lordship, one difficulty, the name of the standing council APDCL is shown. In fact, I do not even have the file. I took the liberty of using your lordship.
AGCL.
AGCL.
But you're not,
We are not for AGCL.
who is there for AGCL?
I think Mr. Deenath appears.
Can you get hold of him?
Very well.
Just inform. A lady of small, daughter not, she says she's not married. If that be so, we'll ask them to examine that. Can you just ask somebody to? Mr. Counsel, you went there with an agreement, right? And that is covered by the rules. There is a rule to that effect. Now, the rule says that you will get that admission out of turn without anything if you undertake to serve in Dhubri for 10 years. You join Hailakandi, sorry. Hailakandi or Hailakandi? Hailakandi. You join. You underwent that course. Now, after joining, you have started making application. You may have problem. Now you want to resign. We'll permit you to resign. Pay 25 lakhs. And you have agreed that you will pay that amount. Page 50.
I am engaged either Digonda Das
Whoever is there.
But now question is that Lordship.
Now you are there. You are the instructing council. Pay that 25 lakhs. We will allow you to go.
They are Lordship in Hailakandi Lordship. They are DT holder. Adjutant Lordship. But there is no OT, no blood, no.
We can't help it, Mr. Council. We can't help it. Once you have agreed,
It's like that.
then you have taken a course. What will happen to that degree that has been sponsored by the state with the undertaking in the rule that you will serve for 10 years or pay 25 lakhs.
I just already completed.
And you have undertaken. I am ready to pay the justified amount somehow as feasible.
Transfer Lordship.
We will not permit you to do transfer.
Transfer Lordship.
No. You're working as on date.
Question is that
Are you working as
they
on date?
provide us signature, I will have no objection. No, no, no. They are.
We will
they
not
are-
go
they are-
even a
they are-
step further than what your undertaking is.
There nothing is
Pay
there.
25 lakhs. Mr. Gugoi, is he working today?
Well, that instruction, I have come for a long, for a long time.
Because he joined
Yeah.
on, when did you join? How is your father's health now, mother's health now? Mr. Council, how is your parents now? What is your date of appointment?
Father,
16. So you'll only have to work till 2026.
Yeah.
2 years more.
and another case is our High Court judgment. Same case.
Name. Party name.
Court is also
Party name. Name of the party.
Dr. Mirajul Hazari.
Mr. Gogoi, you get your instruction. You're working today as on date.
No,
Not working. From when?
from court order.
Right.
From court order, court stay order, court.
There is a stay order here. Wait. Not to take any coercive action.
Also now Mirajul Hazari is also working also. Yeah, got transferred to Nagaur district. I am also agree, Lordship. Give me transfer, I can.
No, we will not permit that. This is a different fact situation altogether. The person was suffering here. Same person was suffering, not the doctor was suffering. Not his family.
No, agree.
Will not permit this. You take an advantage, now you have to suffer the obligation also. Mr. Gogoi, he is not working.
My lord.
Can you just confirm that?
Yes, yes.
Huh?
Sorry.
Get that instruction. We'll direct him to pay the 25 lakhs immediately. You would have to recover.
Already 1.5 years also.
No, we'll not even, if you work for 9 years also, you will have to be bound by this. And get the copy of the agreement. Where is the bond? You have a copy of the bond, Mr. Gugoi?
Well, I will produce that also.
When?
Any
Tomorrow?
day within this week.
Ah. We'll have it on.
Kindly, Lordship. It's very huge amount of it is very difficult for.
I'm sorry,
For
there,
a court
I'll quote judgments of the Supreme Court as well as our High Court when I pass the order. On the same point. And one of the cases would be the cases where I appeared that side. So court did not permit it. I had to pay 25 lakhs. Division bench order. Orup Jyoti Kormapur.
I am agree to work anywhere,
No, you have given up. Now we will not permit this.
but give me facility, Lordship.
Mr. Counsel, we know you are a gynecologist. What your practice, lucrative practice you can build up. You build up your practice. But the public money that was expended on you, you will have to repay. And that is a statutory provision. No sympathy here. Today is 16. We'll have it on 18.
My lord.
On the prayer of Mr. B. Gugoi, Learned Counsel for the petition, for the respondents. Raised it to list this matter again on 18/9/2024. Mr. Gugoi shall place before this court on the next day the bond entered into by the government with the petitioner hearing for bond entered by the petition, bond entered by the government with the petitioner to facilitate him to pursue the postgraduate diploma course. Postgraduate diploma course. Also, Mr. Gugoi shall also receive instruction as to the date from when the present petitioner was not discharging his duties as a medical and health officer. Medical and health officer. 1. Hailakandi, CH bracketed postpartum center from bracket over Hailakandi. Say, Mr. Counsel, you were recruited and you were allowed to do that course for the poor people there, and you undertook that. Now you can't ditch them to be at a lucrative place like Silchar. And how can you? Where is your parents? They are in Nagaon.
Father is already died.
No, where is your mother? Nagaon?
Nagaon.
Huh? Then why Silchar also you will have the same problem?
No.
Your projection in the writ petition.
Everything is there, but Hailakandi there is nothing.
Nothing for whom?
Where there.
Nothing for private practice or nothing for you to practice?
There is some fee.
Listening matter for further hearing on so and so. Next day. Wednesday. You have got him, Mr. Parak.
Yes, sir.
AGCL. Ms. Pukun, you are appearing for AGCL.
Yes, sir.
Ms. N. Pukun, Learned,
3, 4 and 5 year old.
Learned Standing Council, appearing for the AGCL authorities, that is the respondents number 3, 4, and 5, shall receive instructions as to why the case of the petitioner hearing, being an unmarried daughter of deceased Neelakanta Saikia, was not considered for release of pension. Also, the aforesaid instruction be placed on record on the next date of listing.
One extra copy may be provided.
No extra copy, nobody is there. Who will provide you? You
It may
take
be
it from,
reflected in the order, sir.
you take it from here. None appears for the petition of permit. Huh?
Your lordship, our name may be shown in the.
That I'll show. List this matter again on Wednesday, 18/9/2024. Name of Miss N. Pukun, Learned Standing Council,
AEGCL.
AEGCL shall be reflected in the cause list. Also,
Obliged.
you take your notes from here.
Yes, sir.
This is it's number 1, 2, 3, and 5, brother. They are already promoted.
Hmm.
I need some instruction, whether.
Nothing instruction. You are, your specific case is that reserve category candidates were
Yes.
promoted. Who are those candidates? They are not parties here. They are not parties here.
My impact, there is another prayer is that OM has been put to challenge.
Ah, that is already held by my Lord Justice Chaudhary. Then what is that? Withdraw it. If there is something, come back.
Actually, I'm appearing on behalf of Alan Jr.
Whoever, it is, we are not worried. We'll dismiss it otherwise.
Sometime or another date.
Sometime.
Right. Obliged.
Yes, Mr. Counsel, after the discharge order, what is left to be, you present a challenge to that. You have been already permitted.
Lordship, actually, my senior Somnath Das, he was appearing in this case, Your Lordship, for some medical urgency of his mother, Your Lordship. He is in Calcutta, Your Lordship.
On the prayer of Ms. S. Das, Mr. S. Das, Learned Counsel for the petitioner, who is stated to be out of station, comma, raised it to list this matter again. When is he coming back?
Lordship, next week, any date, Your Lordship.
Raised it to list this matter again on 23/9/2024.
Your lordship, regarding item number 3, can it be on 19th, your lordship?
19,
Obliged, your lordship.
19, huh? Item number 319. Yes, Ms. Bora. Hmm.
In this.
Your contention is 26 was not followed. Now they have filed an affidavit. Everything is brought on record there. What is left?
Oh, my lord.
You're working. Why?
Since 2011, Malad, he has this problem, and 2018, then the review medical board again, Malad, 2000.
You are now S5.
Yes,
Will not permit.
My lord, kindly see annexure one of my repetition, page 13.
Since 2011, he is in S1, step 1. Alcohol dependency syndrome, my lord,
Oh.
2018,
Hmm.
page
13, my lord,
135.
annexure one in 2018, my lord, 7 August.
You are now totally alcohol dependent.
My lord, the rule was not followed. That is
Show
not
me,
my
show me,
case.
show me which rule was not followed. Show me what is there to be followed there. Give me a copy.
My lord, I have filed one additional affidavit. Can you see my lord additional affidavit?
Ah. Yes. The rule 26, yes, page 100.
I have got a book also, my lord.
The rule 26. Where is that rule 26 here? Page, internal page?
In the affidavit also, page 140. serial
Page
number.
140. Okay, Mr. Parasar, just show me that provisions of 26(3) were followed.
Where is it, 7 in the annual, yes.
So, my lord, after medical examination, my lord, they have to approach from the, my lord.
Okay, their case is that they had given it to you, you did not accept it.
That is not my case. That is their statement, my lord. That is not correct, my lord. First, they have to, my lord, and my lord.
And is there any report from the civil hospital, civil doctor contradicting this?
My lord, their opportunity I have not been given, my lord,
Why?
because directly they have, my lord, issue me the discharge order, my lord. Kindly see
No,
the
no, no.
discharge order and extra 4, my lord, page 17 of my repetition. And
Where is your reply to the affidavit filed by the
No,
1, 2, and 3? Have you filed a reply?
file, my lord.
reply nothing.
Then
Kindly see one invalid of order, my lord. First,
you
they-
come to page, internal page 15 of the affidavit, para 12.
Yes, my lord. Then, my lord,
You have made an application. Anything more, Mr. Bor, Ms. Bora, you have to submit anything more? Anything more to be submitted?
yes, my lord, kindly see page 37 of their in the position. Page 37, my lord.
Hmm.
Page 37 is the now page serial 77.
The medical board for categorization of personnel. The
Hmm.
medical board for categorization of personnel also shall be convened with a person is considered unit to be in category A when he is to be undergone from a lower medical category. When a medical officer gives an opinion that individual under his medical cover is unfit to perform his duties, who is already in low medical category and requires upgrading, he shall refer the person to the nearest service hospital or hospital whichever is convenient and based on specialist opinion. A categorization medical board shall be convened. All not has been done, my lord. Even I have not been given any opportunity to file my representation. I have many, my lord, opportunity. I can file appeal also. I can file, my lord, medical opinion. from
Who
other
prevented you,
hospital.
madam? Who prevented you?
No, they have not given me such opportunity, my lord. My lord, kindly see, this is a discharge order of another person, my lord. First, they have to approve that order, then they have to give me the copy. Then I will get opportunity for representation or review or appeal.
Mr. Parasar, he is being continued with salaries.
Madam,
Yes,
no
well,
problem, my lord.
that aspect is there.
Why didn't you file an vacation application here?
My lord, no problem, please continue, my lord. Without any
Vacation
problem, my
application
lord.
not filed.
Get your instruction how his condition is on at present.
Yes,
When?
2018,
Nothing is here.
Malat, on Wednesday, my lord.
Okay. On the prayer of Mr. K.K. Parasar Leonard, CGC, raised it to list this matter again on 18/9/2024
No, no,
for further hearing.
After speaking.
For further hearing. So Mr. Parasar shall, on the next date of listing, place before the court the present medical condition of the petitioner. Also, and also apprise this court about the works the petitioner is presently so discharging after the interim directions were passed in the present proceedings. So,
Friday, I have some problem.
Wednesday. Friday you have problem, I know, that's why I put it on Wednesday. Who is appearing for the respondents here, Mr. Pulia? What is this? Show me the inquiry report.
It's not anything that because I
Ah.
have to file my.
You, no, tomorrow, day after, get your inquiry report.
What's it?
You have terminated him on basis of some inquiry report. We want to see what that inquiry.
No, sir, I don't.
If that is not there, we are interfering with full benefit. to it.
No, sir. On Wednesday, Lord, sir.
On the prayer of Mr. R. Gugoi. R. Gugoi?
And the.
NJ Gugoi, sorry. NJ Gugoi, Learned. Standing Council, Assam State Agriculture Marketing Board, registered to list this matter again on 18/9/2024. Also, on the next date of listing, Mr. Gugoi shall furnish to the court the records of the inquiry proceedings so held against the petitioner, including the inquiry report purportedly inquiry report of the inquiry officer appointed to inquire into the charges so leveled against the petitioner. We'll see on Wednesday.
It's a retirement benefit case of the agricultural department, but the name has not been shown, Your Lordship.
SC Agriculture is not shown.
No.
Admittedly after retirement. Admittedly after retirement.
After it.
So if the amount has to be withheld, that can be only withheld after the governor passes an order under 21. That order is not passed. What is the stage of the proceedings?
That I don't know, but I have actually I tried to contact the client, but the client is for the legal counsel who has forwarded the brief, my lord. But he is also not having his number, my lord. So I.
Maybe now by this time everything has gone.
So I don't know, whether maybe.
It is stated in the bar. I heard Mr. J. Roy, learned senior counsel. Also heard Ms. B. Sharma, learned standing counsel AG, as well as Mr. Hazarika, learned state learned government advocate. It is stated at the bar that the respondents, that the petitioner was an employee of the agriculture department, and accordingly, it is the said department that would be required to answer the claim, to deal with the claim so made by the petitioner in the present proceedings. However, it is seen that the name of the standing council agriculture is not reflected in the cost ID. Registry to list this matter again after 2 weeks by reflecting the name of the standing council agriculture in the cost list. We'll see. 10, 11.
Item number 10 and 11 becomes income, sir. They have already appeared.
Mr. M. Kolita, learned counsel for the petitioner, submits that during the pendency of the present proceedings, the issue arising in the hearing has become infructuous, and accordingly prays that the petition be dismissed as being infructuous. The prayer is not objected to by the learned standing council APDCA. So accordingly, prayer is accepted. Writ petition stands dismissed for having become infructuous. Same order in item number 11.
All right.
12 also. खाली advocate का नाम होगा. You are Mr. KD Sharma. 12. 10.
Maybe pass over for the time being, Mr. Lordship, Mr. P.C. Sutia is looking into the matter, but he's on legs.
Okay. Fine. What is here, Mr. Yes, Mr. Sharma.
My lord, this petition pertains to the departmental proceeding
and the consequences thereof. And that the departmental proceeding.
One black mark was removed.
And that the issue is,
But your criminal case also you were acquitted.
I'm acquitted.
Now you say that the disciplinary authority having withdrawn the black mark,
My lord,
you are entitled to the consequential benefits.
my lord. Precisely, this is one. And the second limb of argument is this, my lord. The rule 61, where the black mark is, the punishment of black mark is
Show
enlisted.
me the order withdrawing the black mark.
My lord, if lordship pleases, my lord, may I provide a paper book, my lord, a convenient compliance.
Brief seem to be very, Mr. Hazarika, the brief seems to be a weighty brief.
No, 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 not at all, my lord. He has gone retired, my lord.
Show me the withdrawal order.
Page 44, that rate, Rochester will look into the rate page, my lord. It's printed page, my lord. Page 44.
With immediate effect. What was the background to this, Mr. Hazarika?
Well, may I submit one line?
Hmm.
This punishment of black mark is enlisted in Rule 61.
Hmm.
But the Rule 61 says, my lord,
Hmm.
this rule is not applicable to constable.
Okay.
That is why, my lord, even imposition of this penalty.
Is it applicable to a head constable?
Well, the constable, head constable is same, my lord.
Both are different. It's a promotional post.
My lord, while it was imposed, I was.
Show me that rule 60.
Yes. Rule
It is here.
61. Yes, unfortunately, I do not have proof, so, my lord. Rule 61, my lord, I have made. Take it up.
Mr. Hazarika, don't worry. We're just trying to understand the issue.
Lots.
Constables.
Constable. It's not applicable.
No, A. Black marks may be awarded in lieu of addition to other permission to inspectors, sub-inspectors, assistant inspectors, head constables. It can be awarded.
No, my lord.
Yeah, see, A.
No, my lord, can we see the suspension order?
Forget it. We are on the rules.
No, my lord, can we see? My lord, page 43
Hmm.
of that book, my lord.
Hmm.
It is constable.
But here it is head constable.
Why? My lord, I don't know why it is written head constable.
What are you exactly?
Constable, my lord. Can we see the whole charge, the charge memo, my lord?
Where is the charge memo?
All along it is written constable.
Oh, what are you exactly?
Constable, kindly see page 16, my lord. Is the charge sheet. There is no list of witnesses, no list of documents. There are many limbs, my lord. I will come one after another. And this is constable operation ID number first line. While the department. Then the inquiry report, it is constable page 19.
Okay.
Second line.
Okay. 59. You are Akhil Kumar Sharma.
Yes.
Come to page 67 of the writ petition. of the affidavit, that is internal page 9. You are an assistant sub-inspector of police.
Later on, I was promoted. After the
That
DPP.
means at that point of time, what were you?
That's what I
Mr.
was-
Chutia is in legs somewhere. Mr. Chutia is in legs.
Yes.
Heard Mr. A. Chomua, learned counsel for the petitioner, also heard Mr. Ajarsi Hazarika, learned government advocate. He stated that Mr. T. Chutia would be representing the respondents. Additional senior government advocate would be representing the seniors in the matter. However, he is on his legs when the matter was called up. So accordingly, raised it to list this matter again when? This week?
Lordship, please.
When?
Lordship, please.
Let us have it on 19th. Any problem?
19th of
This month?
this month.
Huh?
I will-
19/9/2024.
Obliged.
Also, Mr. Chutia shall place on record
My lord.
instructions
Yes, yes.
as
Kindly-
to the rank the petitioner had held when the proceedings were so.
My lord, there is an order to produce the record, my lord. It was-
Forget the records, you have given us enough.
Well,
Rank the petitioner was so holding when the departmental proceedings in question were so initiated against him. Only we'll have to see whether you are a constable.
This
If
everyone
you are,
is
if
a
you are, if
constable.
you are a constable, then that black mark normally will not come. Then we need not go into any other aspect. We can take the
Yes, yes,
discipline, the criminal proceedings, apply Gopinath, Ramlal, proceed further.
my lord.
1. 2, if not, then we will have to see.
My sincere submission, my lord. There is an order. passed
Other submissions were not sincere.
The-
No, I forgot. I thought the other submissions were not sincere.
there is an order by this court to produce the record. It may be necessary. If that's it,
We'll
lordship
see if
will-
they want to produce, they'll produce. Mr. Sutia might have it also.
My lord, there is an order, that is why I am saying.
Okay, we will see on the next date, Mr. We'll see,
Lordship, is fixing for the 19th of this.
19. Ask him to produce the records also.
Lordship,
There is an order.
records is there, but this instruction, if it doesn't come by 19th, that's will be 21st or something, if it's possible.
21st is
Or
Saturday.
20, whichever they like, not 19.
23, 9.
Highly on this.
23,
23. A bit little doubtful on 23,
going somewhere.
maybe out of station.
24,
Yes, yes.
24.
Obliged.
Yes, Mr. Doctor.
My lord,
Why the other part salaries are not being paid?
my lord, I need some further time, my lord.
Why? We have been having time from 19.
My lord, this matter was this is only 3 times, my lord, so I need some time.
So we will ask it to be listed from today onwards every day.
My lord.
No, there is
Well,
nothing here to show that he is not entitled. So if we go by the pleadings in the writ petition, he is entitled.
That is why, my lord, some examination is required, my lord. My lordship may fix the matter immediately after the vacation. In the
No, no,
meantime,
no.
my lord,
This man is without salaries. We will not do that. Once the matter has come before me,
because
we'll
this
have to
query is
take it
for
to its-
regularization and then for salary, my lord.
no, I don't find any order denying, disentitling him.
My lord,
And you have not filed even an affidavit.
my lord. So sometime, my lord.
On the prayer of Mr. S. Datta Lanet, Standing Council, Panchayat and Rural Development.
My lord.
Raised it to list this matter again on 23/9/2024. Mr. Datta shall place apprise this court with regard to the stand of the respondents in the matter. We would apprise the court about the stand of the respondents with regard to the prayers made by the petitioner in the present proceedings on the next date of listing.
Obliged.
Yes, Mr. Kumar, what is left here?
Nothing, my lord, but my prayer is only that when I have passed the technical test, my lord, my medical board was conducting, medical examination was conducted. If I am not qualified the technical test, my lord, then medical examination not necessary.
Forget it. Have you filed a reply to the affidavit filed by them?
No, my
Why
lord,
should
not-
we wait? This affidavit was filed way back in the year 2020. Last 4 years, you have not counted that. So we'll go by this. Because this is not disputed. If you have failed in the skill trade test, no further consideration is called for. We'll close that on that. No material, Mr. Kumar.
Hi.
Yes, madam.
Lordship, a senior is on next, Lordship.
Who is your senior?
K. Gogol, Lordship.
Huh?
K. Gogol.
Okay. Let Mr. Gogoi come.
Lordship, can it be fixed any other?
No, no, today we are dismissing it.
Lordship, if Lordship kindly come to page 12, Lordship, annexure 1.
Madam, have you heard what I told him?
Of the writ.
Hmm. Yes.
Clause 23, Lordship.
Clause?
23 of the writ
Ah.
petition. Shall I read?
Will the so and so 10 plus from a recognized board. That is the qualification.
Lordship, the clause annexure 1 of the writ petition, page 12,
Huh?
clause 23, yes, Lordship.
20?
Clause 23.
Huh?
Uh,
Read.
The candidate, shall I read? Lordship? The candidate who qualify in all respects of physical standard test.
Just a
Okay.
moment, madam, just a moment. I think we are not on the same page. My 23 is in page 12 is trade, X-ray assistant.
Lordship, page 12,
12 years.
the detailed medical examination.
Can you give me your copy?
Writ petition.
Just mark it there. Okay, okay, I got it. The candidates who qualify in all respects, that is standard test, physical, written, trade, will be placed in them depending upon the category. So and so. Enrollment will be issued on the final. Please note that merely qualifying in all tests does not guarantee. Okay, this is what you want to rely. Anything more?
Lordship, if Lordship kindly come to affidavit in opposition, page 6, Lordship.
Hmm. Yes, madam.
The respondent authorities published the list of selected candidates on 30 August 2019, in which the petitioner could not accommodate as they had failed in their trade test. Lordship.
Hmm.
And the candidate's mark has given in point 13, Lordship, same page 6. We have, the petitioner have failed to clear all the tests. Lordship.
Anything more? Good. This is how you have to respond. You will have to be ready with the brief. Done. Dismissed. No pass to anyone.
Okay, sir.
Madam, your name?
NN Sharma.
Tell Mr. Gogoi we are recording your name.
Highly obliged.
None appears for the petition on call. It is seen that on the last date of listing also, that is on 1/5/2024, none had appeared, entered appearance on behalf of the petitioner. So the petitioner herein has presented a challenge to the selection and appointment nomination of the respondent number 5 to the post of Muslim marriage registrar, Lakshmipur, Gwalpara. Also, it is stated in the bar that the Assam Muslim Marriage and Divorce Registration Act 1995 has since been repealed, and accordingly, the present writ petition would not be maintained. So, as none has appeared on behalf of the petitioner on call, this court proceeds, would not restrains itself from proceeding to dismiss the matter on merits. However, the writ petition on account of non-prosecution of the petitioner on the last, on today and as well as on the last date of listing, this court proceeds, this court would dismiss the writ petition for non-prosecution.
Okay.
Wait, Your Lordship, I have taken step in the respondent.
You forget respondent, you don't say, come to the issue. Respondent is immaterial. You satisfy me. You filed this case in 23. You retired in 22. Show me, on that day, you had a right for a retrospective. hearing. That much.
Your Lordship,
So you have the rules with you? Rules?
no, Your Lordship.
Hey, yeah, Sana. Pack it up to us in engineering rules. PWD. Irrigation. এটা পালে হ'ল। এই মোটা যদি কিতাপখন আছে সার্ভিসেস ম্যানুয়ালে পুরোনা এখন এই আমার এখন আছে লোকালেক্স হচ্ছে PWD engineering. Yes,
Only respect to
I am bound, Mr. Dury, by one of my own decisions in Itanagar bench. Same issue. Two decisions of the Supreme Court. And there is a latest one called Punam 2023. Because the rules does not provide for a retrospective promotion. So you will be promoted with prospective effect only. Now, if that be so, how can I issue a direction for your promotion after you have retired?
my only grievance is, Your Lordship, the respondent authority ought to have considered my.
Ought to have considered, not considered, now that is gone. That is gone. Anything to distinguish your case?
I was relying.
You are claiming your promotion from 1/1/2022.
Yes, sir.
Agree, amen. Yes, you should have come within that period you were in service. That decisions are 1989 Supply 2 SSC 625. Wherein it says, after a post falls vacant for any reason whatsoever, a promotion to that post should be from the date the promotion is granted and not from the date on which such post falls vacant. Thereafter, that was upheld in 2008-14 SSC. That a promotion takes effect from the date of being granted and not from the date of occurrence of the vacancy or creation of the post. I'm bound by this.
Yes, Your Lordship, but my only grievance was that they ought to have considered my case.
They ought to have, if you had come within that period, we would have maybe come in your favor. But you filed this writ petition after your retirement.
Yes.
And if I direct it, it has to be prospective. They can't promote you today. So, Mr. Dury, I'm sorry.
Right.
Did you get that earlier order that was uploaded?
Yes, I got.
Dismissed.
I'm getting to respond number 7.
Mr. Bishop. Who is appearing for the department? Mr. Azorika, you will appear for the irrigation department. Gogo is there. You are appearing? Irrigation? Yes, what do you have to say? Why did you not promote him? Why?
Anupati is
Face law or something else law?
Anupati is appearing in this.
Forget Anupati. Where is Mr. Anupati?
From other court.
Huh?
Ultimately under another court.
He is another. Okay, we'll put your name. During next time, another case.
Let me do.
Yes.
I'm appealing to the.
Yes, Mr. Hopper. You were Mr. Yes. Show me your terms and conditions. Where is your terms and conditions? No, that should be with you. There is a specific direction here by this court on 9/6/2023. So you have nothing other than those representations and forwarding by the minister. Nothing is there. Okay, fine. We'll close it. Yes, Mr.
I'm appealing to both of them. We will find details reply.
Huh?
We will find the affidavit in 2 weeks time.
Why? Why affidavit? What is your stand?
In fact, he has misappropriated the amount. More than he has taken.
I'm not on that. Misappropriation is not an issue here. Issue is whether his dues have been released to him or not. Right? What do you have to say on that?
He's not in that.
Why? Just tell me that. Why? Only on that much point. I mean, why is he not entitled? Tell me, I'll close him up.
This was honorarium.
Huh?
He was honorarium by the appointment.
So some honorarium was due to him.
No,
What was that honorarium?
he was getting facility.
Where is it prescribed that what he will be entitled to? Somewhere it should be prescribed. Huh?
I'll take his second.
You take your instructions, we'll have it on Wednesday.
Friday.
Thursday.
Friday.
Thursday.
Friday.
Friday may be a little bit difficult because I'm having a division bench. Thursday. On the prayer of the Learned Standing Council, you're for Amtrot. Amtrot. Raised it to this matter again on 19/9/2020. The Learned Standing Council, Amtrot, KL Gupta, shall receive instruction as to the entitlement of the petitioner for the period he had worked as chairman of the said corporation. Heard Mr. A.R. Sigdar, Learned. I'll put Mr. Sigdar, Learned Council for the petitioner. Also heard Mr. C. Hazarika, Learned Council appearing for the respondent number 1 to 4. 1 to 3. Also, Mr. B. Sharma appears for respondent number 4. Tell him. We have put his name here. Also, although the notice was served upon the respondent number 5, none has entered appearance on behalf of the said respondent. Also, the present petition was the petitioner had instituted the present petition claiming pension and pensionary benefits in respect of the services rendered by her husband, late husband, ASI bracketed Operation Abdul Majid Alam, being his first wife. Also, the petitioner has filed an additional affidavit in the matter and therein has brought on record agreement, memorandum of understanding entered between the petitioner and the respondent number 5 hearing, in terms of which it was agreed that the pension, gratuity, leave encashment, GPF shall be shared amongst them in equal ratio of 50/50. Also, in view of the said understanding reached by the petitioner and reduced to writing via the memorandum of understanding dated 28/3/2022, the Learned Council for the petitioner has submitted that the present petition be disposed of in terms thereof. Also, I have considered the matter. I have considered the submission so advanced by the Learned Council for the petition. Also, noticing the memorandum of understanding got on record between the petitioner and the respondent number 5, comma, the present writ petition stands disposed of in terms thereof. Also, the interim order passed by this court while order dated, interim directions passed by this court by order dated 16/8/2023 would stand vacated. Also, in view of the above, the present writ petition stands disposed of.
Possibly also there is an NCR.
Is that here? This is a maintenance case.
Yes, so Lordship, order.
This is only a scan copy. Yes.
Service not complete.
No affidavit.
My lord, I'm appearing for response number 1 and 2, my lord. My lord, we will file affidavit in this matter, my lord. 4 weeks time will be granted, my lord.
Subject to Mr. Dasgupta agree.
My lord, because my lord, same case already been, my lord, not entertained by this honorable court, my lord. There is an order that if any settlement is made between the parties in and reference case is disposed of on the. basis of
Settlement under
settlement.
what? 18(1), 18(2)?
Yes, 18 is binding, my lord, between the parties.
No.
Now,
18 which clause?
18, yes, my
There are subclauses in 18
lord.
or only one?
Yeah.
Tripartite between the majority union and.
One, my lord. I will place that order also on record. All right, let them file it. So, my lord, without telling you that, my lord, award as well as settlement.
Mr. B. Das, learned. Council appearing for the
Question number 1 and 2, my lord.
response number 1 and 2. And Mr. You are for? And Mr. Central and Council appearing for the response number 4. Submits that they be granted 2 weeks time to bring on record their respective stands by way of filing an affidavit. Prayer is not objected to by Mr. A. Dasgupta and Council appearing for the petition. Accordingly, registered to list this matter again after
4 weeks, my lord.
4 weeks on a date 2 weeks.
My-
Also, in the event of filing of any such affidavit by the respondents, the petitioner will be at liberty to bring on for a rejoinder if so.
Marks. Obliged.
Time being given in order for. Okay. You are appearing for the private respondent.
No,
Earlier,
number
my lord.
8, my lord.
Respondent number 8, you are appearing.
Yes, my lord.
Yes, what do you have to say?
My lord, today, my lord, I am not prepared, my lord, this case.
Then
The
Mr.
last
B.
order, your lordship, last order, C, my lord, 59 to.
Ah.
Right. Last order, my lord, 59/2023, my lord.
Earlier occasions, they have represented the department, my lord. There are several rounds of litigations, my lord. WPC as well as contempt.
Yes, what do you have to say?
Last order, my lord, 59/2023,
Absolutely.
my lord. Direction is given to file affidavit, my lord.
They are fine.
My lord, as to how the center was
That
established
is
in the private.
already,
my lord.
already fine. Now, only thing you will have to tell me that earlier round of litigation, earlier round of proceedings, both here and before the authority, there was a categorical finding that you are outside the area. Possing Kolyamari,
Question, my lord.
there is Kolyamari. You are beyond Kolyamari. You will have to cross Kolyamari, then come to Possing Kolyamari. Now, how come you are now thereafter selected? And where is this Anganwadi center working? In the original survey area or in some different area?
In some different, my lord.
Where?
Government has filed affidavit.
Oh, where? The government does not say that.
From a private
You
house.
have not filed a rejoinder to that.
My lord, as the order was not as per the High Court order, my lord.
Mr.
And my
Bora,
lord,
Mr. Bora, I understand.
My
that-
lord, respondent number 8 has donated the land, my lord.
Now you will have to show
Telling
me.
the government that they have not enforced that document.
Forget it. Now you only, your client is there in the field.
Right.
Your client should come up and tell this court that, see, this is not within the original survey area. Finish. But
But
if
they
this is within the original survey area, she has a land there, how can we hold her to be not within that area?
Therefore, court has directed.
Forget the court direction. Do you want to file a
My lord,
rejoinder to
I'll-
this?
I'll-
File it by this week, next week,
I'll-
by Friday. We'll have it on
Okay.
23rd. We'll have it on 23rd.
23rd. I'll-
On the prayer of the learned Mr. D. Bora, learned counsel for the petitioner, who submits that he be given a week's time to file a rejoinder to the affidavit filed by the respondent number 2 on 19/1/2024. This was filed on 19/1.
Right.
19/1/2024. So as a last chance, an opportunity is given to the petitioner. So registered to list this matter again on 23/9/2024. So the respondent number 8 shall on the next day. Learned counsel for the respondent number 8 shall on the next day demonstrate that the petitioner, that the respondent number 8 initially had resided within the coverage area of the Anganwadi center in question.
My lord, Mayor paper 23th, my lord. Instead of
25th.
23rd,
25th, done.
23th. Of late.
Lordship, in this case, during the pendency, my lord, already, my lord, the four petitioners already promoted. the
That's what I'm saying. Where are those people who have been, who superseded you? They're not parties here. 1. 1610 challenge is already answered by this court. What is left here? If something is a withdraw, come back. First. Mr. Ellen Dinya, learned counsel for the petitioner, submits that few of the petitioners in the meantime have been promoted to the post of professor.
Professor.
Full stop. However, submits that petitioners number
Petitioner number, my lord, 1,
1,
2,
2,
3, and 5.
3, and 5 were promoted. Were promoted to the rank of professor during pendency of the present proceedings. Miladi, good day. Full stop. However, the grievance with regard to the other petitions, that is petition number 4, 6, and 7, continue to remain. So, Mr. Dinya has further submitted that the challenge in the present proceedings to the office memorandum dated 3/8/2016 has already been answered to by this court in WPC number
5005 2016 and
WPC number 505
5005 2016 and 5026 of 2016.
and 5005 of 2016 and WPC number
026
526 of 2016.
66 2022. my lord.
Full stop. That is my Lord Justice A.D. Chaudhary's order. In view of the above position, Mr. Dinya submits that he be permitted to withdraw the present petition with liberty to refile the same, if so advised, if so mandated. Full stop. Prayer accepted with petition stands dismissed on withdrawal with liberty as free. Come back, make them those people the party respondents. Otherwise, how can you maintain a mission? Mr. Singh, how is your father now?
Still in ICU, but lot of improvement.
Oh, thank you.
Make each other.
My lord, the issue is, my lord, that regarding, my lord, that production of this document, and you want to exhibit this document. Now, your lordship.
Now, Mr. Sharma,
Yes.
on the last date, Mr. Singh had demonstrated
Yes.
that the FIR is the complaint petition.
Yes.
It had this as an enclosure. The original copy was somehow not produced. But subsequently, the original copy, he could come to lay his hand on that, and accordingly, he has afraid. You will satisfy
Yes.
me.
My lord, in this case, my lord, then in that event, my lord, the intent of the prosecution is very important. Your lordship may kindly see the evidence of PW4. That evidence, see at the vernacular
Page
at page
13.
15, your lordship.
Page 15.
Page
Here, PW4 is Mr.
The Mr. Babu Datta.
Babu Datta.
In whose position this document is supposed to be.
Hmm.
Your lordship means bottom side.
Azahar Kari, we read the whole thing.
Yes, the bottom part is important.
Hmm.
Committee number খেলিমেলি দেখি মই stamp paper সম্পাদিকাৰ পৰা টকা দিম বুলি লিখাই ল. Now he has mentioned about this document in his evidence.
Hmm.
Now suppose under
Now you come to the cross.
your lordship,
Moi,
মই
page 16.
যোৱা দিয়াখন কাগজখন ফটোকপি আছিল.
Hmm.
ফটোকপি আছিল 2000 চনৰ সদস্যৰ খেল হৈছিল আৰু ইয়াৰ পৰা সদস্যই খেলিব নোৱাৰে যিজনে বেছি দাগ দিব পাৰে তেওঁৱে বেছি খেলিব দাগ মাৰি টকা লৈ ঘূৰাই দিব
And
লাগে
those are not required.
নাই your lordship yes পুলিচক কৈছিলো যে মই এইটো মই যে পুলিচক কৈছিলো যে
So there was a question put. And he replied that I had given a photocopy. So
Photocopy.
at least a
It's not-
photocopy was
your lordship.
not exhibited, but it
Exhibited.
was a document.
Yes, your lord. Now, here's the question is that, my lord. In law, my lord, suppose if the document is lost, they want to exhibit it. There is an option, your lord. They could have filed an application that time to, my lord, exhibit as a secondary evidence. They produce it as secondary evidence. They were under 65 of the Evidence Act, they are permissible. Whether they have met this intention or not, because they did not intend to exhibit this document at that point of time, any point of time. Now, PW1 also in the neither of this evidence is evidence chief, my lord, he mentioned about this document. Now, FIR has been lost by the PW1. Now, if it is along with this FIR, he had the knowledge, PW1, that is informant. The informant in his evidence, my lord, never mentioned about this document. Now, PW4 just mentioned that I had obtained a stamp paper.
No, in his evidence, he has, the PW4 has indicated about the document.
Yes, your lord.
And there was a cross that whether, what is it? It says it's a photocopy.
Photocopy. And
And
that,
then the application that he is filed,
yes, your lordship, may kindly see what application he has stated. That page 10, your lordship,
page,
page 10. That the case is now fixed for recording of statement of the accused under section 313 of CRPC. The PW4, Babul Datta has adduced evidence who was having an agreement after the notice anomalies in the running committee by the accused. In his evidence, he has verbally referred to about the agreement, and even he was cross-examined on the same by defense. Since the original was not readily traceable, my lord, it was not lost. Because they did not, my lord, make any effort to make it trace the document, trace out the document. Now, TPW1, as per the application, he had the knowledge, my lord. The informant had the knowledge about this document.
I knew that. And he has referred to that also with the document in his position. Secondary evidence in his position. Subsequently, he comes to lay his hand on the original. And if that document would help the court in resolution of the issue, why will the court not accept that?
My lord, it's a fill up to filling the document. Like now, my lord, he's trying
Now,
to fill up the lacuna.
your case is that this is
He's
the
trying to
filling
fill
up
up
of
the
the lacuna.
Yes.
Show me how.
My lord, your lordship, my colleague. His intention was not to exhibit the document. I have already mentioned.
You mean to
Because-
say even the secondary document was not offered for?
Yes, before the court, he has to file an application. If court would have rejected the application, then it would be different case. He did not have any intention to exhibit his document at no point of time, either PW1 or PW4.
So that's your case.
That is it. Fill up the lacuna, my lord. That is the only thing.
Your case is to fill up the lacuna.
Yes,
If he had the intention to do it, he could have done it at that point of time, along with an application
exactly.
requiring the court to accept the secondary evidence in absence of the loss of the original one.
And this application was filed after my cross-examination. Your Lordship. In cross-examination, I put that whether it was original was given to the police. He said no. Then he is trying to fill up the lacuna. That
Okay.
is the
Yes,
matter.
Mr. Singh. His allegation is that this is to fill up the lacuna. And that is one of the grounds of the Supreme Court also said You cannot permit anything to fill up the lacuna.
No, my lord, on that day,
You were referring to certain judgments.
my lord. That day I
We
was-
have accepted the fact that this was a part of the FIR. We have accepted it. It was
in the
also
first-
in your statement when you made, you had referred to that. A cross also was made as to why you said it's a photocopy. Now, the allegation of Mr. Sharma is that you had not submitted an application requiring the court to accept it, which
At
is
that relevant.
at that present point of time. So you did not have an intention. Now, when you, after the cross and all, you found some lacuna, now you are trying to bring this in. What do you have to say on that?
There are two answers, my lord. Section 311, on that day I was referring that the entire section, the first half you will find the verb may, and in the subsequent
It's this.
part shall.
एक one direction, CRPC funding. Oh, give me. I'm trying to understand this, so I'll require your assistance more.
My lord. It will be my
Both
pleasure,
of
my
you.
lord, if I can be of any assistance.
This is something which I'm learning. Yes.
Any court may, at any stage of any inquiry,
Trial
trial, or other
proceeding.
proceeding, under this court, summon any person as a witness or examine any person in attendance, though not summoned as a witness, or recall and re-examine any person already examined, semicolon. And the court shall summon and examine or recall and re-examine any such person if his evidence appears to it to be essential to the just decision of the case. Now, my lord, it is up to the court. It may recall. But if the court comes to a conclusion, or if this honorable court thinks that this document was always a part of the complaint petition, was referred to and relied by the prosecution, but somehow it did not have the original in hands at the right time. Now, whether any sort of embargo can be read under section 311, the subsequent part, my lord, where the verb used is shall. Now, it is up to the honorable court to decide the essentiality of this document.
No, here the reference is not there to a document. It's only to the examination of the witness.
No, no,
It'll
examination and
also in
evidence-
whether it'll also include production of
Examination and evidence always includes oral as well as documentary evidence, my lord. Now, the judgment the other day, my lord, I referred to, correct, my lord, the 2013 judgment. Whether the copy is available, my lord, otherwise I have brought the.
You can give me a copy. I'd say.
Is it available?
Mr. Sharma, 2013,
2013 was referred
Supreme
by
Court.
me, Supreme Court.
3081. It's there.
3081.
It's there. You're referring to para?
Paragraph 14, my lord. If we come to the last part at page 3085, my lord. Therefore, a reading of section 311 CRPC and section 138 Evidence Act, insofar as it comes to the question of a criminal trial.
No, 1 second. Hey, where are you reading?
My lord, page 3085, paragraph 14.
There is no page number here. Paragraph?
May I provide my own copy, my lord?
Para 14, you can.
It starts like this, my lord, in the middle portion. It is therefore imperative that the invocation of section 311 CRPC
Just para 14, na?
and its application in particular case can be ordered by the court
It is therefore imperative, yes.
only by bearing in mind the object and purport of the said provision, namely for achieving a just decision of the case as noted by us earlier. the power vested under the state provision is made available to court
At any
at
stage.
any stage in any inquiry or trial or other proceeding initiated under the court for the purpose of summoning any witness as a witness or for examining any person in attendance, even though not summoned as a witness, or to recall or re-examine any person already examined.
Okay.
Insofar as recalling and re-examination of a person already examined, the court must necessarily consider and ensure that such recall and re-examination of any person appears in view of the court to be essential for the just decision of the case. Therefore, the paramount requirement is just decision, and for that purpose, the essentiality of a person to be recalled and re-examined has to be ascertained. To put it differently, while such a widest power is invested with the court, it is needless to state that exercise of such power should be made judicially and also with extreme care and caution. Now, my lord, there are two more things that I would like to highlight. Is to come to paragraph 23, my lord. After referring to many judgments,
Clause M.
not only clause and the entire 23 paragraph, my lord, ultimately summarizes the basic ingredient of section 311, basing upon the previous judgment of the Honorable Supreme Court. So your lordship can look into clause B, clause C. Clause B reads like this: the exercise of the widest discretionary power under section 311 should ensure that the judgment should not be rendered on incoherent, inconclusive, speculative presentation of facts, as thereby the ends of justice would be defeated. If evidence, C, of any witness appears to the court to be essential to just decision.
I got
of
it,
the
Mr.
case.
I remember it. I got it. Anything, any further paragraph?
Now, my lord, along with M and N,
M and N, yes.
there are further judgments which make things more clear, my lord, that even document can be brought.
Give me a judgment on that.
Now I am referring, my lord, 2014 Criminal Law Journal 40872.
This was not given yesterday.
This
That's it.
was not given earlier. no. Supreme Court. Only come to para 10 and 14. Right? If your lordship first come to para 14, things will be clear. In this case, what had happened, my lord? The sub-inspector who had done the investigation, my lord, he had not brought certain documents on record. Para 14. If we view the present case in the light of the above judgment, we will have to sustain the High Court's order. PW 15 SI Dayal Mukherjee stated to the court that he had recorded the statement of deceased Rupchand SK. Thus, this fact was known to the defense. He was cross-examined by the defense. Inadvertently, the said statement was not brought on record, though PW 15 SI Dayal Mukherjee Rupchand SK died after the said statement was recorded. The said statement therefore become very vital to the prosecution. It is obvious that the prosecution wants to treat it as a dying declaration. Undoubtedly, therefore, it is essential material to the just decision of the court case. Though the fact of the recording of this statement is deposed by PW 15 Dayal Mukherjee, since due to oversight, it was not brought on record. Application was made under section 311 of the code, paying for recalling of PW 15 SI Dayal Mukherjee. This cannot be termed as an inherent weakness or a latent void in the matrix of the prosecution case. No material is tried to be brought on record surreptitiously to fill up the lacuna, since the accused knew that
Okay,
the such
got it.
statement was filed. Now kindly come to para 10 of this
Yeah.
judgment. The principle is there now. What is the aim and object of section 311? After referring to the aim and object, my lord, ultimately the Honorable Apex Court allowed the statement that was recorded by investigating officer Dayal Mukherjee of the deceased before he died, which was never produced earlier. But it at least makes things clear, my lord, that the document can also be introduced.
Yes. Then next.
Now, one more allegation, my lord, is that this is nothing but filling up the lacuna. In this regard, one judgment I would like to highlight, my lord. This is again from the apex court. This is 2022 Live Law SC, page 662. Kindly come to paragraph 38. Having dealt with the satisfaction of the requirements of section 311, we deal with the objection of the respondent that the application should not be allowed as it will lead to filling in the lacuna of the prosecution case. However, even the said reason cannot be an absolute bar to allowing an application under section 311. And this observation, my lord, is based on an earlier previous Supreme Court judgment which has been referred to in paragraph 39. In the decision in Zahira Habibullah Sheikh versus State of Gujarat, which was more recently reiterated in Godrej Pacific Technology Limited versus Computer Joint India Limited, the court specifically dealt with this objection and observed that resultant filling of loopholes on account of allowing an application under section 311 is a mere subsidiary factor, and the court's determination of the application should only be based on the test of essentiality of the evidence. So if your lordship thinks that this document, which was always a part of the prosecution story, is very much essential for the true facts to come on record, then this may kindly be allowed, my lord.
Okay. Now we have
Your
understood
lordship
the,
come to para
okay, para?
40, my lord, of the same judgment. The right to the accused to a fair trial is constitutionally protected under Article 21. However, in so and so, while reiterating Rajendra Prasad, the court observed that it is the duty of the criminal court to allow the prosecution to correct an error in interest of justice. Now, if we consider, my lord, that there was some inadvertent plea on the part of the prosecution, and that now needs to be corrected, then they have the opportunity to cross-examine.
So Rajendra Prasad has been quoted.
Rajendra Prasad, yes, my lord. And I have brought the Godrej specific judgment also, my lord. I am providing the copy. Great admirer of Justice Arijit Pasayat, my lord. So whenever any judgment comes in my hands of Justice Pasayat, I refer. Kindly come to paragraph 8, 9 and 10. The object underlying section 311 of the code is that there may not be failure of justice on account of mistake of either party in bringing the valuable evidence on record or leaving ambiguity in the statement of the witnesses examined from either side. The determinative factor is whether it is essential to the just decision of the case. The section is not limited only for the benefit of the accused, and it will not be an improper exercise of the powers of the court to summon a witness under the section merely because the evidence supports the case of the prosecution and not that of the accused. The section is a general section which applies to all proceedings, inquiries, and trials under
I
the
got it,
court.
sir. Para 9 also, the later portion.
And para 9, 8
The later
and 9,
portion.
my lord, ultimately
It's for the court
signifies
to
and
decide.
shows that in case if there is any sort of
That is
giving of
subsidiary.
loopholes,
That is subsidiary.
subsidiary. And why it is said so, my lord, because the accused have the ample opportunity to deny and
cross-examine.
cross-examine.
Okay.
Obliged.
Yes, Mr. Sharma.
My lord, this Ryan declaration, my lord, that regarding that judgment, my lord, it was a clear case that police investigation, after investigation, that IO did not bring on the record.
Now tell me, what is the material that would be there in that agreement? How would it further the case of the prosecution, or how would it damage your case?
My lord, please say that I made some declaration that refunding this amount. It is a game. It's a game of it's a betting. Somebody has to bet their bet fee. And we can play this game for a longer time. It would be beneficial. So I have not seen the document, of course.
No, document is here.
But the thing is that, my lord, it is not like, my lord, how is it feasible? Now, at this stage, whether that can be, my lord, feasible after processing, and that the argument at the time of, my lord, argument stage. It is in the
ইয়াৰ
argument.
দ্বাৰা মই চুক্তিবদ্ধ হলো যে মই পৰিচালক হয় মই বহুত প্ৰায় 20জন সদস্য এই বাবুল দত্ত এজন মোৰ কমিটিৰ সদস্য হয় এই বাবুলৰ ৰূপে ঘৰ পালি গাঁও আমাৰ কমিটিৰ প্ৰফুল্ল দত্ত Right, দিবলৈ প্ৰস্তাৱ থাকিব।
But criminal law, that's why, my lord, civil law, criminal law is something different. Criminal law is prosecution has to prove the case beyond all reasonable doubt. And accused should not be prejudiced to any of these states. Now, civil law is something different. It's a probability. That's why I'm saying whether they have, if this document is a very important document, why we did not make any intention, my lord, at that point of time? Even PW1 did not mention.
Now, tell me, show me a decision of the Supreme Court that if there is any such document required to be produced,
Yes.
secondary evidence, that an application has to be made there and then,
At that point of time,
that point of time,
That
and
point.
not subsequently.
not.
Any decision to that effect? Or which provision would of the CRPC would support you of that contention?
Because of, because it is, my lord, it's a rule of law. my
I know
lord.
that.
While you are producing a
But
document,
the
you
decision
have to
Mr.
make an
Mr.
application.
Singh has produced,
You have to make an application.
it reflects that can be also subsequently
No,
done.
my lord, that you see, your lordship will have to make an application before that we have law.
Just give me a decision to, in support of your,
I have not,
give me a decision in your support. I'll close the matter.
Yes, sir.
You can give me a written submission
yes, sir.
in that. And you can
Yes.
very well give your decision on that. Give a copy to Mr. Singh also.
Yes.
Mr. Singh, otherwise we have got your points. You can also give me if a one single page thing, just your stand in the matter. And also deal with the importance of that document. Deal with that agreement that she has, a declaration she has
Highlight
made.
in 2 lines sentences, my lord. She was taking the defense that she was in no way connected with the committee and the
I know
collection of the money.
Just
Here she-
put it down. What is the importance of that in the context of this defense taken by the petitioner? And also refer to your, and I'll keep it for orders, delivery of orders. When can you give me that? 2 page, you need not be here. When can you give me that? Day after?
Next week.
Huh?
Next week, day after tomorrow, my lord.
Monday? 23rd. 23rd? You give it to my footmaster on 23rd. I'll list this matter on 25th for delivery of orders. Mr. Singh, you need not be here. We're great, thankful that you are here today, but given your condition, you should not be here.
I hear this.
Obliged. Your junior can give it to my footmaster. Heard the parties at length to raise this matter again on 25/9/2024 for delivery of orders. Also, the parties are at liberty to bring on record their respective submissions, written submissions, but on or before 23/9/2024. Just indicate the cases you have referred to. I've gone through it, just indicate that. Okay.